Amendment states, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. This amendment is meant to protect those accused or found guilty of a crime and ensure that the punishment fits the crime. Of course, this amendment is quite vague, with words like excessive, cruel, and unusual all being subjective to individual perceptions as well as societal norms. Let's take a look at the three clauses of this amendment separately. A person accused of a crime is often allowed a period of freedom before facing their trial by paying an amount of money. This practice is a part of English legal tradition dating back to the 13th century. To prevent bail, some judges charged excessive amounts they knew the accused could not pay. So in the English Bill of Rights of 1689, a provision was included stating that, quote, excessive bail ought not to be required. This was eventually included in the U.S. Bill of Rights. One thing that remains unclear, though, regarding bail is whether the founders intended everyone to have a right to bail, regardless of the crime. Although not included in the current Constitution, the Massachusetts colony had made exceptions to providing bail to those accused of capital crimes, and this has largely been a tradition the courts have upheld. There have been very few Supreme Court cases involving the excessive fines clause of the Eighth Amendment, but there is one notable case in 1998 in which a defendant had been found guilty of violating requirements when transporting money internationally. The defendant had been forced to forfeit over $300,000 due to this violation. The court ruled that the punishment was not proportionate to the crime, which is a general principle that is also applied in the other clauses of this amendment. Most cases concerning the Eighth Amendment have had to do with the last clause. There have been debates as to whether the standards of cruel and unusual are fixed, meaning they are based on the times in which the Bill of Rights was written, or whether they are evolving. A somewhat similar debate exists in regard to the Second Amendment and firearms. For example, in the case Wilkerson v. Utah in 1879, a man was sentenced to death by firing squad for committing first-degree murder. The Supreme Court did not regard this as cruel and unusual punishment, but did state that executions like drawing and quartering, beheading, and burning alive were forbidden by the Constitution, since they would have likely been considered as cruel and unusual at the time of the Constitution's framing. In the 20th century, the court ruled more flexibly, arguing that the standards should evolve with the times. For example, in 1910, the court ruled that 15 years of hard labor was cruel and unusual as punishment for simply falsifying a public document. Not all cases have involved physical punishment. In the 1958 case, Trop v. Dulles, the Supreme Court ruled that it was cruel and unusual to strip a person of their citizenship as a punishment for desertion. When it comes to the three parts of the Eighth Amendment, the court has seemed to stick to the idea that punishment should be proportional to the crime committed. It also seems clear that our understanding of terms like excessive, cruel, and unusual can and should change with the times.